We are back June 29th, 2025. Unfortunately, I am pre-recording this video as I have to be on the road at 7 p.m. Doing some traveling here this weekend, so I won't be able to bring you guys the show live. However, next weekend, I'm hoping to bring you guys back to live coverage. I did not want to miss a weekend, so I am pre-recording this, and I'm going to put it out at 7 p.m. Eastern Standard Time, just so you guys can get the latest and the greatest that's in the news on the IP front. And we got a lot of stuff to cover as we go through here. We're going to be bringing out through the interview of the week, Reaction Technologies. We'll go through that. T.I. and Tiny, they're back in the news, this time getting sued for trademark infringement for their movie, I think, called Situationships. So we'll talk a little bit about that. Fair use. It seems like this AI copyright battle is heating up more than ever, in a federal court just ruled or made an important ruling that I think is going to change things. But ultimately, again, I believe that the Supreme Court will ultimately be the last, have the last ruling or the last say so in this whole kind of AI copyright fair use battle. So we'll talk a little bit about that. It seems like the world first waterless or plant-based waterless paint has been invented, and so we'll kind of talk about that a little bit. And then the IP of the week, or the lawsuit of the week, which we'll pull up the copyright or pull up the complaint, go through that, and that's Lululemon has sued Coscto. And I have some interesting things about that and why, just any brands who are selling with these companies such as Sam's Club and Costco, why you shouldn't be surprised when something like this happens. Again, you got to do what you got to do as it relates to enforce your intellectual property, but why these kind of brands should not be surprised when a Costco or a Sam's Club or any wholesaler for that matter is kind of doing what Costco is doing in this part. So we have a lot to cover. Please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. I do have some new merch coming out. Finally, I want to actually have an interesting story that I'm going to get off into based on the merch. You see the Peace, Love, Intellectual Property shirt. Now, I actually have on the shirt, but the shirt that I have on, I've had for a number of months, and I did not want to sell this one, even though this is the shirt that I get the most compliments in. Peace, Love, Intellectual Property. People come up to me, hey, what do you know about IP? Now, I'm able to tell people that not only am I an IP practitioner, but now I am an IP owner having copyrights. I'm looking to come out with some trade secrets as well as trademarks here very, very, very soon, as well as a patent that's in the works. So again, I am able to tell people that I'm not only an IP practitioner helping people protect their patents, trademarks, and trade secrets, but also in copyrights, but also I own intellectual property. So this is actually a good shirt for kind of being able to have an icebreaker, people coming up to you, as opposed to you having to kind of go up to people and try to kind of tell them about your business, pitch your business. But people are going to definitely come up to you in this shirt. And like I said, this one that I have on, I did not. This is something that it was kind of the material was regular, but I kind of bought them because I was using them myself and I wasn't selling them. However, and as you can see here, let me kind of, I just picked them up. Peace, Love, Intellectual Property. These shirts are the real deal, man. The quality is like amazing, definitely better than a shirt that I have on. The quality is amazing. You can see, obviously, it's two different companies, because on this one, the one I have on, I have the SC, but this one doesn't have the SC. So I have these in white. I have them in black. Then some of them just have the Peace, Love, Intellectual Property on the front. Some of them have the Got IP also on the back. So definitely go check out the link in the description. Go support that. Like I said, this is not only cool from a supporting standpoint, but this is also going to act as advertising and marketing for your business, because as opposed to you having to go up to people and tell people about your business, what it is that you have, I guarantee you that people are going to come up to you and say, hey, I like your shirt. Hey, what do you know about IP? What is your role in IP? And that's a great way to be able to tell people about your business, about your product, about the service that you're offering. So definitely go check those out. The link is in the kind of description section. But I did want to kind of bring you guys a story, and I'm going to kind of bring up this video where, and I'm not sure if I'm going to get a copyright strike on this, but I think this is worth kind of showing the importance of kind of intellectual property branding and knowing what is kind of right as well as what is not right. So Myth Bleak, who, for those of you who don't know, he's like a very loyalist to Jay-Z. And he was talking about in this clip, which I'm going to bring you guys on the Breakfast Club, I think it was a couple of weeks ago, how kind of State Property was a brand name that was owned by Benny Siegel, another member of the State Property, and how Dame Dash, which we all know Dame Dash has been in the news for one reason or another, was kind of trying to, uses IP without kind of going about it the right way. And I want to play this clip because I had an experience, a really similar experience with my manufacturer of these shirts that I'm kind of selling at this point. Now, we was able to work it out, hop on the phone, chop it up. I was able to kind of give my perspective. He was able to give his perspective, and seems like we had a truce on this one. But if I wasn't an IP attorney and I did not know what I know about intellectual property, hey, it seems like things I would have been getting over on. So I wanted to kind of first play this clip by Benny Siegel because he's essentially telling you what I had went through, but he's kind of relating it back to Rockefeller and state property, Benny Siegel. Then I'm gonna give you guys my thoughts on how this kind of applied to my situation and how I was able to overcome it. Now, again, this is something that you can apply as well. He's just kind of giving you the problem. I'm gonna tell you how I dealt with it in my situation and how you can do it as well if you find yourself in the same similar situation. So let's kind of go here and make sure I have this thing on the right speed. I know some of the times I listen to these things on. Okay, it's right. So let's go.
Do this. I used to be telling these guys, yo, it's only a matter of time before it's over. We got to get this right. And they used to look at me like, whatever. Like, I remember a time, right? Beans had his clothing line, state property. We used to get clothes, boxes of state property. So I'd look in state property and say, manufactured by Rockaware. So I'm telling him as a brother, yo, bro, check your contracts and all that. Make sure everything right. Like, because I see it's manufactured by Rockaware. I don't think Rockaware was making their own clothes. So how they making your clothes? Like, just as a businessman, this was like, didn't seem right. And this was at the time when he was saying, yo, I'm going to jail. I'm going to sign Freeway and the Young Guns to Rockefeller. When I come home, they going to give them back the state property. And I'm just sitting there like, oh, you think business work like this? So I'm trying to tell him these things. Like, he looked at me. This is when I knew me and Beans the relationship wasn't the same. Because he was like, yo, it sound like you hating on me, fam. And I'm like, what you mean? He like, yo, if Jay your man, like you say, why you ain't got no record label? Why you ain't got no clothing line? Dang, my man, he taking care of me, all this. And I'm like, I feel you, but you know why I don't have those things? Because my bro would never exploit my ideas for him to make a bag. Damn. That's what you need to realize. They're taking your ideas. And then when he came home from jail, what he said, they ain't owe me $2 million. Should have listened to Blizzle. But like I said, Jay not my man though.
So look, this was an exact situation that was kind of happening to me. So for those of you who kind of really wasn't following along, Benny Siegel, which was an artist under Rockefeller that was owned by Biggs, Dame Dash, and Jay-Z. Obviously, we know Rockaware was the big clothing brand that was essentially owned by Biggs, Dame Dash, and Jay-Z. And next thing you know, Benny Siegel, which again was one of the artists under Rockefeller, he had his own clothing brand called State Property. Now, again, that brand was owned and that ideal came from Benny Siegel, not the original owners of Rockefeller, Dame Dash, Jay-Z, and Benny Siegel. And it seems like at this point in time, according to what Memphis Bleak was saying, they were starting to break apart. So Jay-Z went his way, Dame Dash went his way. And it seems like Benny Siegel followed Dame Dash. So prior to Benny Siegel going to jail, he had the State Property clothing line. And like I said, Rockaware was owned by Dame Dash and Jay-Z, and they were selling clothing. But next thing you know, the State Property brand, and again, I guess going back to that Rockaware and them selling clothing, obviously Rockaware is a brand. They're not manufacturing their clothing. They're going to a manufacturer who has the shirts, who has the pants, who has the gear, and they are essentially manufacturing the gear and printing the Rockefeller brand on the gear. And then they're providing it to Rockaware, Dame Dash and Jay-Z, and ultimately the consumers are buying it. However, Dame Dash and Jay-Z they're not manufacturing the clothes themselves. They're going to a manufacturer to manufacture the clothes, put their Rockaware label, trademark on it, brand name on it, and then they are selling it to the consumers. And in this case, Benny Siegel, who had a state property brand, this is what Memphis Bleak is saying here. The clothing, it seems like they're trying to say, when you see it, even though it's a state property brand, they're trying to say, hey, this is manufactured by Rockaware. And Memphis Bleak is like, hold on, Rockaware they're not even manufacturing their own clothing. They're going to a third party to manufacture the clothes. So how are they manufacturing your stuff? It seems like what they're doing is they're owning the IP, the trademarks to state property, that's what Dame Dash was doing. It seems like that's what Memphis Bleak was alluding to, that Dame Dash was owning the trademarks or the IP to the State Property brand, and Benny Siegel did not know that. And a big part of that was because he saw the State Property brand and it was saying manufactured by Rockaware. He like, hold on, Rockaware not even manufacturing their own clothing. So how they manufacturing your stuff? But it was essentially a white labeling where Rockaware or Dame Dash had the manufacturer white label the State Property brand as if Rockaware was manufacturing it as opposed to the actual real manufacturer. And the reason I'm saying all this is because when I got this shirt, Peace, Love, Intellectual Property, and again, I actually have a pending trademark on this shirt. However, and I'm gonna cover up the tag here, but the print company who was printing the shirts, they were buying the shirt. The print company that I have for this shirt, they bought the shirt from a third party, and then they printed the shirt based on what I wanted on there. They actually put their logo on the shirt, on the tag, and I called the guy up like, hey, what's going on, man? This make it seems like that this is I'm not going to say the company name, but y'all making it seem like this is your shirt that I'm selling. And I'm like, no, I just had y'all print my name on the shirt, print my IP on the shirt for me to sell. Y'all didn't manufacture the shirt. Y'all just printed printed what I want y'all to print on the shirt. So the fact that y'all took your brand name that y'all got trademarked and printed on my shirt as if this is your, essentially getting free marketing and free advertising as if it was your company, that's BS. And it can come across to somebody buying my shirt like that. This is not my brand. This is your brand, and I'm selling your brand. And again, like I said, we had a productive conversation, me and the owner of the print company, and we worked out a truce and all this love going forward. But this is essentially the same thing that Memphis Bleak is saying, how, hey, Rockaware didn't own State Property, or they weren't manufacturing the shirts. They went to a third party, got the shirts. The third party was manufacturing the shirts, and Rockaware in this case, they weren't even printing the shirts. The third party was printing the shirts, and all Rockaware was really just a middleman. They weren't even printing the shirts. At least in this case, the company that I was going to, they was actually printing the shirts, even though they got the shirts from the manufacturing company. But I did not like how they printed their logo on my shirts. I just wanted y'all to print my logo on the shirts. I don't know why y'all decided to print y'all logo on the shirts. That's bad business. So again, that's a takeaway for any of you guys out there who are going to a third party to print y'all shirts, print y'all brand name, y'all logo on the shirts. They should not be printing anything unless they're literally manufacturing the shirts, which most print companies aren't manufacturing the shirts. They're getting them from a third party. Unless they're manufacturing the shirts, they should just be printing your brand name on the shirts, because that's what y'all paying them to do. To the extent that they're printing their logo on the shirts or their brand name on the shirts, that's bad business. That's not how that should work. Because again, it can be looked at to the consumers, to the people who buying your shirts off you, as if this third party or the print company is their shirts because it has their logo on it along with your logo. No, if you guys have your logo on the shirts, if you're printing a print company to put your logo on the shirts, that print company should not be printing or should not be putting or printing their logo at all on your shirts. Now, the manufacturer, in this case, if they want to keep the manufacturing tag on there, then that's cool. If they want to put if you say, hey, put your you want your logo on the shirt, that's cool as well. But the company that's printing your shirt should not be printing their logo on your shirt. They should be printing what you are paying them to print on the shirt, and that's it. So to the extent that these print companies are printing their logo on your shirt, that's bad business. Because they're getting a shirt from a third party, from a manufacturer, and they should leave that manufacturer tag on the shirt to the extent that it's on there, and just print on the shirt what you want them to print on there. Like I said, I had that situation, and I went through it in real time, so it was interesting because I watched this video like a week or so ago, and I actually just got the shirts back, and I'm like, hold on, that's bad business, man. Don't be printing y'all logo on my shirt. I paid y'all to print my logo on the shirt. Get the shirt from the third party and print my logo on the shirt. So the fact that y'all printing y'all stuff on the shirt, that's bad business. But again, we worked it out and all is well. So hopefully you guys understood that. Please let me know in the comment section if you guys did. If not, then I'm not sure how kind of clear I can explain it. But yeah, like I said, I just went through it in real time. So all that being said, go purchase Peace, Love, Intellectual Property, the shirts. The link is in the description. At some point, I'll get a QR code so that we can do it that way. But for now, go purchase the shirt. It's white and black, and then you got the IP on the back of some, and then not on the others, and they're available in small, medium, large, extra large, and I think I have a few double XL. So go check them out. Go purchase them. Go support. It's going to be a big advertising and marketing to your brand to the extent that you have a brand. But if you don't have a brand and you just want to support, go check them out. So let's see here, man. Let's go to the interview of the week. Reaction Technologies. This guy is actually pretty cool, man. Brandon, he actually moved up to Detroit from Texas, and he has an interesting story of what made him start the company Reaction Technologies, and he's been crushing it so far, man. So I'm going to play a snippet from this interview, and I'm going to come back and I'm going to kind of give you guys my thoughts on what it is that he's doing and kind of go from there. So let's go. Kind of take this off the screen and make sure this is on just the normal speed. It is. Let's go.
So we were founded after we seen a 13-year-old football player become paralyzed in a football game from using incorrect tackling technique made to tackle with the crown of his helmet. Our product is an accessory that wraps around the tackling dummies these schools or organizations already have. And so as a player is running in to hit the tackling dummy in practice, a coach is going to change the number on the screen. And if that player comes in using improper tackling technique with their head down, they won't be able to tell you that number on the screen. So ultimately what we're trying to do is we're trying to give coaches a tool to be able to help. The most critical part of the tackle is the collision point. Is your head up? Is your head down? Our product also too is going to be used at the higher levels of football, not only because of safety, but because of targeting costs. Coaches are actively looking for ways to minimize these type of hits because it's affecting the outcomes of the games. You know, when I got to take out my starting middle linebacker in the first quarter of the game, and it's a national championship game, you know, this puts my team one step back. So we really believe we got a product that can enhance athlete safety.
Oh, man, shout out to Brandon. Go check out that interview. He's dropping, not only is he dropping game, but I just like the fact that he took a story. For those of you who didn't know, he was watching some type of story on a kid who seems like maybe went in for a tackle, ended up being paralyzed as a result of going in for a tackle. And the story motivated him and moved him to the point that he created this device. And I think it's patent pending. I'm not sure if he got an issue patent on it. Maybe he did get an issue patent. I can't think offhand, but he talks about it in the interview. And it's really an accessory. So you saw it, this kind of strap that goes on a tackling dummy. You can actually wear it on yourself as well. And for those athletes, we always, especially playing football, you always hear the coach say, keep your head up, keep your head up, keep your head up, especially with going in for tackling. This Reaction Technologies, this device helps you keep your head up, because when you're going for the tackling, you got to see the number that's on a bag to the extent that you make the tackle, and the coach asks you what was the number and you don't know it. That means that the head was down. So this kind of helps you reinforce positive reinforcement to keep your head up while you're tackling. And it's also is able to be used in just football, but other sports. He talked about lacrosse. He talked about rugby. He talked about soccer. You saw it also in basketball, doing drills when you're dribbling the ball. And again, especially as you're younger, you want to kind of have your head looking at the ball down, looking at the ball. But this is a device that as you're looking at the coach and you're dribbling, you got to be able to kind of continue to see the number while you're dribbling. And as a result of that, having your head up. So it's really helping out in a lot of other sports, not just football, but basketball, like I said, soccer, rugby. And again, he created this thing. This is why I love, inventing, because you create this thing for a particular application, particular use case, which in his case was football. But next thing you know, he finds all these other use cases, other sports, lacrosse, like I said, rugby, soccer, basketball, and he's crushing the game. People are using this not only from Little League, but all the way up to colleges, university, and the professional athletes. So shout out to Brandon. Go check out that interview. Like I said, he moved up here from Texas to Detroit. He's been crushing it ever since. So, yeah, shout out to Brandon, man. We're going to move along here. Hey, I was out in Vegas last week. I think I had an interview that I had put on last week, but I want to play another interview for you guys. And this time, this was me interviewing SpongeBob. So this interview is actually done pretty well on the YouTube. So I wanted to play this, guys, for you. Me interviewing SpongeBob. Hey, SpongeBob, it wasn't no dummy up under that suit. So we're talking about intellectual property. So let's see the questions that I asked to SpongeBob, and let's see what SpongeBob is talking about. Let's go. So I'm here in Vegas. I'm outside of Planet Hollywood, and I'm here with SpongeBob.
Yeah, love it.
So I kind of briefed SpongeBob on what we're doing. I'm an intellectual property attorney. I told him his boss is protecting him using 2 out of the 3 major forms of intellectual property. And actually, your boss, I'm not sure if you know this, they made like $14 billion using your character over the last 2019. So they're making a lot of money off of SpongeBob. Did you know that?
Whoa, I was not familiar. I should use some of that money myself. Ah,
And I'm not sure what your cut is, but I'm not. I would imagine that it's not a lot. So
not a cent.
So this can be your big break.
Yes.
If you answer the question right, you get $20.
I'm ready.
So we have patents, we have trademarks, and we have copyrights. I'm gonna say each one, and it's 2 out of the 3. So if you can guess the 2 out of the 3 right, like I said, I'm gonna give you $20. So do you think that your employer, your boss, is protecting you by way of a copyright?
At the moment, yes.
Okay, you 1 for 1 so far. Do you think your boss is protecting your character by way of a patent?
No, by a trademark.
Hey, man, I think you hustling me, SpongeBob. You got it right. So he's correct. His boss is protecting him by way of a copyright as well as a trademark, not by way of a patent. So SpongeBob, he got the 2 out of the 3 right. He's going to get $20. Now, what are you going to do with this $20? Are you going to get Squidward anything? Are you going to get Sandy anything? Or are you going to keep it all for yourself?
I'm going to give it to Gary because Gary needs more treats down below.
There you go. There you go. Well, I appreciate that, SpongeBob, and we're out. Hey, you the real deal, man. Hey, shout out to SpongeBob, man. Hey, I tell you what, SpongeBob knew what he was doing. So for those of you who don't know, I think Viacom owns SpongeBob currently, or at least the IP to SpongeBob. I know at one point Nickelodeon was obviously SpongeBob, the show was on Nickelodeon. But SpongeBob, the character, is protected by way of not only a copyright, but also a trademark. So patents, obviously, SpongeBob is, as he correctly said in an interview, his employer or his boss is not protecting the character by a patent, but trademark and a copyright is what are the two forms of intellectual property that SpongeBob is protected by. Which again, just kind of giving you guys more information. You can protect, especially 2D works, logos, which obviously SpongeBob is a logo as well as a 2D work. You can protect those by way of both copyright as well as trademarks. He got the question right. Hey, as soon as I gave him that $20, man, hey, his voice switched up, man. His voice switched up quick. So definitely go check out that interview as well as other interviews that I did while on the Strip in Las Vegas last week. Let's move on here to situationships. So T.I. and Tiny find themselves back in the news, this time for being sued for trademark infringement. I did a full video on this, so I'm not going to kind of go through the whole video, but for those of you who don't know, T.I. and Tiny actually was awarded like $70 million a couple months ago for their OMG girls, OMG Dolls. I think T.I. and Tiny, their daughter, was one of the members of the group. MGA Entertainment infringed on their dress trademark without their permission. And as a result of that, T.I. and Tiny sued them for dress trademark infringement and was awarded. The jury awarded them $71 million. So I think MGA, I think it was some issues on whether or not the district court judge was going to uphold that decision, and he actually did. So I'm not sure if MGA is going to appeal that. I'm sure they will. But as of right now, MGA owes T.I. and Tiny $71 million, which again goes to the fact that, hey, man, this intellectual property is valuable. So this time around, it seems like T.I. and Tiny is being sued by another Georgia resident over the trademark situationships. So as the title of the article points out, a situationship film T.I. and Tiny, I guess, put out on BET Plus this film entitled Situationships. Let me know if you guys have seen that film in the comment section. I don't typically watch TV a whole lot these days, unless it's sports or whatnot. And as a result of them putting out that film Situationships, they were infringing on the Georgia residents' trademark of situationships. So Georgia resident, I think she had a podcast as well as a TV series called Situationships. She owned the trademark for that. And, again, T.I. and Tiny not only did not get permission from her to use the term situationships, which she had trademarked, they actually filed for T.I. and Tiny did trademark protection on the term situationships, and the USPTO rejected that trademark in light of the Georgia resident situationship for her films and podcasts. So, and this kind of leads me to another point. If you're filing for a trademark and the USPTO rejects your trademark application based on a registered trademark that's out there, obviously this is not take it to the bank. But you probably going to have that company's probably going to not only sue you if you continue to use that mark without their permission, but they're going to point back in their lawsuit to the fact that your trademark got denied for the term in light of their trademark. So that's exactly what happened to T.I. and Tiny in this situation. They tried to file for a situationship trademark based on their film, but the trademark application was denied in light of the Georgia citizen, the Georgia resident, her trademark for her podcast as well as her TV series entitled Situationships. And again, T.I. and Tiny, they went ahead and put out the film anyway. And next thing you know, they got slapped with a trademark lawsuit. So again, just understand what you're getting yourself into as you are using these trademark terms. I actually have a big surprise in a couple months on a tool that's going to help you guys do this and hopefully avoid lawsuits the way that T.I. and Tiny has kind of put themselves in. But again, there you go. T.I. and Tiny sued this time on a wrong side of a lawsuit for trademark infringement. Go check out that full video that I have that I did on the channel, on the YouTube channel. As we move along here, fair use. Somebody say fair use. Now, I've been bringing you guys these AI copyright battle, these lawsuits, and this is like the third or the fourth installment on this. For those of you who don't know, these big tech companies have been using, they have these AI models, and they've been using this copyrighted subject matter to train the AI models. Now, again, you almost have two sides of the coin. You either have the AI model or you have the data. A lot of times these big tech companies, they have the model, but they don't have the data to train the model. And a lot of times that the data is copyright protected. So these AI companies were using all this copyright subject matter, in this case, authors for the books. They were using these copyrighted books to train their AI data, and the authors band together and sued the tech companies, in this case, Anthropic, for copyright infringement. Now, Meta found itself in a similar situation. I did a video on that a couple months ago where some authors sued Meta and Mark Zuckerberg for a similar thing, copyright infringement, by using their copyrighted books to train Meta's trains Meta AI machine, or essentially models, LLM, large language models. So it seems like in this case, a federal judge ruled that, hey, these tech companies can in fact use your copyrighted books to train their models, which, man, that's a big ruling. It was out of California. So it'll be interesting to see how things continue to progress in light of that. But this is a big blow to copyright owners, particularly book owners, and it's a big win for tech companies. Now, the district court did rule that, hey, you have to buy the book. So you can't steal the book or pirate the book and then use it to train your copyright model. You have to at least pay for the book, and then based on that book that you own, you can use that book to train your AI model. So that's essentially what the district court ruled. Like I said, I think that the Supreme Court ultimately is going to have the final decision on this. For those of you who don't know, this is how cases get to the Supreme Court. Because we all know that the Supreme Court of the United States, they get to hand choose and pick their cases. But so you have three levels with regard to IP, because IP is a federal thing. So you have three kind of levels in the court process. You have the district court ruling, you have the circuit court or the court of appeals ruling, and then you have the Supreme Court's ruling. So the district court, so for example, in Michigan, we have an Eastern District, we have a Western District. The Western District is on the west side of the state, the Eastern District is on the east side of the state. So in this case, this district court was in California, one of the regions in California. But if you have and then when you go to the Court of Appeals, that's kind of based on a region, right? So I think it's Sixth Circuit that's in the Midwest, which I think is like Michigan and a couple other states nearby. That's like the Sixth Circuit. Then I think on the West Coast, you have the Ninth Circuit, which is like California and some neighboring states. But what happens is when you have the circuit courts or the Court of Appeals, when they have like different rulings. So in this case, the district court ruled in favor of the tech company. So say that gets appealed to the circuit court, and the circuit court maintains that ruling in favor of the tech companies. And say the circuit court in Michigan rules in favor of the book owners. Now we call I think it's like a circuit split is what it's called. In the Supreme Court, when you have Court of Appeals that are ruling on two sides or different sides of the coin, now the Supreme Court wants some uniformity. They want to know, they want to kind of make a ruling so that everybody knows how these type matters are going to be are going to be ruled on. Because again, if that's the case, if you are in Michigan and you're looking to essentially put out a book, then you're going to stay in Michigan. But if you are a tech company and you're looking to essentially not pirate, but if you're looking to use somebody's purchase somebody's book and use it to train your company, then you're going to go out west, because now you're going to be within the Ninth Circuit, their jurisdiction or their ruling, which is in favor of the tech company. So Supreme Courts don't like when the Court of Appeals, they have different rulings to a same issue. So they will take that matter up and they will ultimately come up with a ruling. And that ruling has to be followed by all the courts, judicial courts, as well as the Court of Appeals. So ultimately, I do think that the Supreme Court eventually is going to take this matter up. And who knows what they're going to decide. But, you know, again, I'm always favored IP owner, which in this case is the book owners. But, hey, man, with this AI stuff, I think we're all kind of racing to our demise anyway. So hopefully you guys understood that. Let me know what you guys think in the comments. And if you're a book owner, let me know what you think. This is a big blow to you guys, your book owners, your you know, the copyright owners for books. And to the extent that you're a big tech company and you're watching this, hey, you know, congrats for now on that. So let's move on to the next one, which I thought was an interesting topic. A waterless, really a plant-based waterless paint. And this is the world's first patent on plant-based waterless paint. Now, I don't know a whole lot about kind of paint and the composition of it, the chemical properties of it. For those of you who don't know, as a patent attorney, you have your different niche, so to speak. So the electrical engineers are going to deal with that. The chemical engineers are going to deal with the chemicals type of technologies. Biology is going to deal with the biology technologies. The mechanical is going to more or less deal with the mechanical technologies and kind of so forth and so on. Software dealing with the software technologies. And in this case, obviously, we're talking about paint. We're talking about chemical compositions. And it seems like Paint Zero is the name of the company. Secures the world first patent for the plant-based waterless paint. I actually do have a video that I'll play for you guys just in case you were wondering, they're similar to me. Hey, what does this even mean? So this is essentially a video from Paint Zero on their new waterless paint. You get it in a mail, some powder, mix it with tap water and get the paint. Different colors, all good to go. So that's pretty much it. So for those of you who look, man, I'm a real estate owner, and typically when I go to Lowe's, Home Depot, Menards, or some type of paint store, I get the paint. They're prepared. It has a number of different properties in there for, that's essentially mixed up at the actual paint store, and then I'm leaving with a bucket of paint that's already ready to go. Where in this case, it seems like it's a dry powder that comes in a bag or a box or whatever the case may be. You take it home, you mix it with tap water, and next thing you know, it's ready to paint. Now, I'm not sure the quality of this. That'd be interesting. So to the extent that you've used this, it seems like this company is actually out of the UK. But to the extent that you're watching in the UK or they're selling this in the US and you have used this, let me know what you guys think of it. As you see here on the right, 0 toxins, 0 oils and plastics, 0 films, 100% sustainable, paint you can trust. Now, I'm not sure if people are going to gravitate towards this. I guess for the right price, we'll definitely try it. But ultimately, I'm not sure. It'll be interesting how much this kind of gets people going and gets people to to purchase it. For me, I just want a quality paint, and I can tell you, all paints are not created the same. This seems like it's a powder, as you see here on the right hand side. This powder that you literally are mixing with tap water out your faucet. And heck, all water is not the same depending on where you're getting your tap water from. You mix it up and you can kind of paint. So I would imagine that the process of having to transport paint, kind of prepare it, that's substantially reduced, which ultimately seems like the paint will be cheaper. But it seems like I'll be concerned with the quality of it, how it applies to the wall, how's it look, how it holds up over time. Seems like those questions are kind of big questions as we kind of go through it. But again, the world's first patent for plant-based waterless paint. There you go, not using fossil-free. So it's fossil-free paint. So let me know what you guys think about that in the comment section as we move on to the lawsuit of the week, Lululemon. And I actually have, I'll wait to play that video. We are going to kind of pull up the lawsuit. Before we put it up, Lululemon has sued Costco. Now, I'm more of a Sam's Club guy, but a lot of times when you go to Costco or Sam's Club for that matter, they are selling these brand names, whether it's Nike, whether it's Puma, whether it's Lululemon, they're selling their products. But typically, I know Sam's Club has member mark. I'm not sure what Costco have. So in other words, these wholesalers have their own kind of brand that they sell that's a lot of times is cheaper than the name brands that kind of are being sold as well. And as I was saying at the beginning of this video, you shouldn't be surprised because at least in my opinion, what I think all these wholesalers are doing, they know what's selling because they're selling the product. Then I think what's happening is, and again, we'll go through the lawsuit. I think as a result of Costco and Sam's Club and these wholesalers knowing what's selling and them having also their own personal brand that they sell from a clothing perspective, they are trying to mimic what's selling and then put that out there and sell it to the public. And these brands are getting wind of it and they're suing them for trade dress or trademark infringement. I think Sam's Club had been sued for, I want to say Nike or some clothing brand a while ago for a similar matter. And the good thing about clothing is, even though it's tough to get a utility patent on, you can get not only a design patent, but you can get trade dress protection on the clothing that goes at the non-functional aspects of the clothing, which we'll talk about as we get off into here. But it's really a way for you to protect your particular designs. And to the extent that these wholesalers or anyone for that matter is trying to kind of trade on your goodwill, trade on your popularity, you can slap them with a lawsuit. So it seems like that's what happened here. Lululemon felt like Costco was trying to trade on their popularity and all the money that they were making. And Costco ultimately, or Lululemon ultimately, sued Costco for trademark and trade dress infringement. So let's kind of pull up the article here and see what they have to say. Please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. Let's go. This is the final one for segment, and then I'm gonna get you guys up out of here. Let me see here. Okay, here we go. This is cool. Let me knock this down. So this is in the Central District of Cali. I'm going back to Cali. Lululemon is the plaintiff, is suing Costco for trade dress infringement. Let's kind of go through it here really quickly. Lululemon is a path-breaking athletic and lifestyle apparel company founded in '98. I didn't realize it was a Canadian company. Lululemon designs, manufactures, and distributes innovative, unique, high-performing apparel, footwear, and accessories that have achieved remarkable consumer success. Since its inception, Lululemon has been pioneering products that are sought after by athletes as well as growing core of consumers who desire everyday performance wear consistent with their lifestyle. So it seems like these are some of the popular kind of lifestyle brands: Scuba, Define, and I guess ABC pants, which at least Define and Scuba are trademarked. That's why you see the R in the circle. As a design and innovation-led company, Lululemon has invested substantial effort and resources to develop, promote, and protect its brands and innovations. Lululemon, I'm not sure why they don't have Lululemon capitalized, but I guess they're doing that because that's the brand name and that's how it shows up. Product design is a process is driven by extensive research, guest feedback, and testings to develop high-performance products with innovative design concept, impressive construction techniques, and strategic fits. As a result, consumers in the U.S. and around the world recognize, enjoy, and rely upon Lululemon's trademarks and creative designs. Okay, Lululemon files this action as part of IP enforcement. You got to protect that IP, directed to retailers who have chosen to copy rather than compete. So it seems like Lululemon is saying, hey, compete with us. We're going to win anyway, but we'd rather for y'all to compete. But if y'all going to copy us, we're going to slap y'all with that lawsuit. So Costco has unlawfully traded upon plaintiff's reputation, goodwill, and sweat equity by selling unauthorized and unlicensed apparel, employing knockoff, infringing versions of plaintiff's well-known trade dress and design patents, and to recover fully for the monetary damages and significant harm to the brand. Let's see here, man. Upon information, believe the research sell dupes. Okay, upon information, I believe one of the reasons retailers such as defendant Costco desires to sell dupes of plaintiff's product is the potential for confusion and perceived association between the dupe products and Lululemon's authentic products that such scale create amongst their consumers that benefit the retailer. Indeed, one of the purposes of selling dupes is to confuse consumers at the point of sale and to observe post-sale into believing that the dupes are plaintiff's authentic products when they are not. For example, the Washington Post published an article titled, "Is that a hoodie, a Lululemon, or a Costco dupe?" That's not good with when a magazine publication or a magazine company such as the Washington Post is saying this. No one has to know but you. As another example, the New York Times recently published an article titled, "Are these $20 Costco pants a Lululemon dupe?" Yeah, that's not good. But we're going to take a look at the dupes, the pictures, and you are going to be the judge and the jury. So we're going to skip the jurisdiction and venue. We're going to go to the factual background. There's a lot of pictures in this one, which is a good thing because I'm more of a picture guy myself. Since '98, Lululemon have designed, distributed, strategically marketed, offered for sale, and sold premium athletic and casual lifestyle apparel and accessories under the trademark brands Scuba, Define, and ABC Pants. Plaintiff's products have widespread recognition. Consumers understand and have come to expect Plaintiff's products to be at the forefront of design, creativity, high quality, and unique innovation in the athletic and casual lifestyle apparel market. Now, I will agree with that, man. I see a ton of people wearing Lululemon stuff. Now, I don't own any Lululemon stuff, but I see a ton of people wearing it, really men and women alike. So it's not even just a woman thing, but I see a lot of men rocking Lululemon apparel as well. Let's go to the IP protecting plaintiff Define apparel. And we're actually just going to go to the pictures here. So again, this is actually, and I know this is a trade dress as opposed to a design patent, because a design patent will have a D in front of it. This doesn't have a D in front of it, so I know that this is a trade dress protection or trade dress application. And like I said before, similar to trade dress and design patents, and I'm gonna kind of bring it back on me. For those of you who don't know, trade dress and design patents is very similar. Trade dress has to be a lot more distinctive and is looked at or is examined a little bit more closely, because trade dress is similar to or subset of trademark law, which again, what we know about trademark law, it lasts forever as long as you're using it. Design patents only last 15 years. So the examiner at the USPTO, when you file a trade dress application, they're going to examine it for distinctiveness a lot closer and with a lot more scrutiny than a design patent, because they know that if I approve this trade dress application, it's going to last forever, as opposed to a design patent only lasts for 15 years. So that's the only difference between a design patent and a trademark or trade dress protection. And kind of as I pull back up the screen here, we're going to see that, hey, you can't protect the functionality of clothing. So for example, you can't protect the pocket. You can't protect the zipper, but you can protect maybe how that zipper looks, how the shape of that pocket, but you can't protect the pocket itself, because it's a functional item. You put your hands in, you maybe the pocket, you maybe put stuff in there, so you can't protect the functionality of that. However, the way things are, look, the shape of it. In this case, you see the stitching, which is this is the Lululemon product. They I guess have a trade dress protection on kind of this particular pattern on their item, the clothing jacket, which you see the arc up here, the curved lines going on each side from that upper arc all the way to the bottom. Similar thing here. Well, you have the two curved lines going from kind of the neck area all the way to the bottom. Seems like you have a stitching that's going across, more so in the middle of it as opposed to at the top. So these are the different designs that they have protected via trade dress protection, at least with regard to this Define jacket. So they're saying the registered Define trade dress has been used exclusively and continuously by Lululemon since at least 2009. Lululemon has also acquired extensive common law rights in the distinct overall appearance and the design of its Define jackets, comprised of the following unique combination. So this is the actual product of it. Before we were showing you guys the actual trade dress application, this is what it actually looks like. So again, similar to what we were saying, you see those kind of curved lines on each side going from the top all the way to the bottom. You see that kind of stitching going kind of across, kind of similar at the middle of it. Now, you're not going to be able to protect this zipper because that's a functional item, but this stitching, which is non-functional, is more so on the ornamental use of the look and feel of it. You can protect that. And Lululemon has a protected trade dress protection on that. Again, you see the back of the jacket here. They have that kind of, this stitching across the back. They have trade dress protection on that, along with, it seems like, those lines on each side of that kind of that transverse stitching. So that's what they're saying here. Let's go back to this again, another jacket by Lululemon. Again, you have a trade dress protection on those two kind of red lines, as you can see pointed out, going from the top to the bottom, as well as this kind of stitching that's kind of going across the jacket. So when they call, I think the curve or the middle line that extends across the mid region of the jacket, the back of the jacket. So that's what they're calling right here. That curved line, and then an approximate mirror image of the curved linear ornamental line from below the ornamental line across the mid jacket of the region shows the bottom seam. So I think those are what you see in here in red. So we're going to skip all this and kind of go to the next one. Seems like they're talking about how celebrities are kind of wearing their jackets. I'm not sure. Only kind of names that I'm familiar with is Kate Middleton. I'm not sure Nicole Kidman, Reese Witherspoon. I've heard of that name before. Kourtney Kardashian. Obviously, we heard of the Kardashians. Leanne Rimes, and Kelly Ripa. So all been spotted wearing Lululemon jackets. So it seems like the celebrities rock with Lululemon. As a result of Lululemon long-standing and widespread use, sales, and promotion of the defined trade dress, the public has come to recognize products bearing the defined trade dress as emanating from Lululemon associate such products with the high quality of goods and services. I'm not sure. Let's see what this is. Trade design features do not make up the product design of the elements of the design trade dress are not a competitive necessity. So they're pretty much saying, hey, this is not functionality. It's not functional. It's not necessary. Again, if something was functional in the clothing, you cannot protect it by way of a trade dress or a design matter. You only can do non-functional matters. And it seems like, let's skip this. This, again, they're talking about the intellectual property for the scuba product. So I guess the jackets with the defined product. This is the scuba products. We can, again, go see here again. You see everything that's shown in dotted lines is not protected. Everything that's in solid lines is protected. So I'm assuming it seems like that hoodie, that shape of the hoodie is protected, as well as, again, these kind of curved lines on each side of the front portion. And again, they give you some actual clothing items. You see the lines here on each side of it, as well as kind of on the back side. You kind of see these lines, which are protected as well. This is the Lululemon product. I think they're showing these other brands just to show that, hey, outer known woman's high-tooled hoodie. They're just showing you how others look in terms of you got the other popular brands, Tommy Hilfiger, where they don't have that same stitching, that trade dress protection as Lululemon has, and therefore it goes to show you that, hey, the stuff that we're protecting are not functional items. I mean, non-functional items. Yeah, they're not functional items. It's not like we're trying to protect a pocket. We're trying to protect a zipper. We're protecting non-functional items, and they're giving the Tommy Hilfigers and other brands to show you that, hey, these other brands don't have what we have in terms of our stitching, our patterns that we have protected by trade dress. And this is another Aeropostale, as well as an H&M oversized hoodie. You can see that these hoodies don't have that same stitching, that same pattern that we talked about above, that Lululemon is protected by way of a trade dress protection or a design mark. So that's essentially what they're saying in those paragraphs. I'm going to skip the ABC pants. These seem like these are men's pants. Again, like I said before, Lululemon not only has women clothing, but they also have men's clothing as well. And everything is in red. They're pretty much saying it's protected by way of trade dress protection. They're saying how, again, Tommy Hilfiger pants, they got the Dockers. They don't have that same pattern, that same trade dress protection that a Lululemon has. So they're just kind of going to show you that, hey, the stuff that we are protecting is non-functional, which is one of the standards that you have to get a design patent or trade dress patent or trade dress protection. And they're showing that by way of other clothing brands, Tommy Hilfiger as well as Dockers, in this case, not having those same stitchings. This is another one. Bombos, I haven't heard of that. H&M related big cargo pants. So let's go to the defense infringement activities, and then we're going to get you guys up out of here. Lululemon brings this action to combat Costco's importation, distribution, advertising, marketing, offering for sale, and sale in the U.S. of apparel that infringes upon essentially Lululemon's products. Upon information or belief, Costco is a large online brick-and-mortar retailer that sells a wide variety of apparel. That's pretty true. Costco has imported into the U.S. a number of different items for selling. Lululemon wrote to Costco. It seems like November 11, 2024, so late last year, Lululemon sent a cease and desist letter to Costco about its infringing the intellectual property of Lululemon, Costco subsequently removed at least some of the product that infringed Lululemon's IP. So it seems like they were complying at least to some of the stuff. Upon information, I believe Costco imported it to the U.S., distributed, advertised, marketed, offered for sale, and sold at least the information below. So this to the left is Lululemon trade dress protected items, and this is what Costco sold. So again, the Lululemon brand to the left, and I'm assuming that the Dan Skin, that's the Costco brand. What do you guys think? Let me see if I can blow this up a little bit. You see this? You see those lines here on the left as well as the right? What they're pretty much saying is, hey, Costco have the similar lines to the left and to the right. And again, this is my opinion. It seems like I said before, these wholesalers such as Sam's Club and Costco, they're seeing what's selling. And as a result of it, they, with their personal brands, are going to try to mimic what's selling. But a lot of times, these brands such as the Lululemons, the Nikes, they have trade dress protection on their popular items, and therefore when you do this, you can kind of open yourself up into a lawsuit. I think they have at least some type of cause of action. Let me know what you guys think. You see again on the Lululemon hoodie to the left, you see those lines on the left hand and the right side, and it seems like Costco has a similar lines. Let's kind of go down to the next one. Lululemon to the left, Costco to the right. Again, you see the Lululemon, kind of those curved lines to the left. It's kind of hard to see. And the right here, if you follow my cursor, you can see Costco has that similar line here to the left and to the right. So I think Lululemon has some type of a cause of action. Now you see the jacket here. Lululemon is to the left. You see, if you look at my cursor, you see that line running down the left-hand side and the right side from the top to the bottom, as well as that kind of curved line going through the front. Now, I do think that in this case, Lululemon may be reaching. I don't see that line going across the middle. In the Costco brand, it seems like it's kind of a faint line going from the top to the bottom. But I think with regard to this jacket, I think Costco may be all right compared to the Lululemon one. But hey, heck, you're going to throw it in there and see what sticks. But I do think with the back of it, as you see here on the left-hand side, the Lululemon brand, you got that curved line going across. And then you got those two lines, curved linear lines going down the left and the right. I do think that Costco, that back of the jacket is a little bit more kind of closer than it probably should be. I don't think the front of the jacket, I think they may be okay with that, but I do think the back of the jacket is problematic. Again, similar with the front. Seems like that curved line is down a little bit lower, but seems like that stitching, man, it's similar, man. Go throw it in there and leave it up to the judge or the jury to decide. Obviously, I think it's a lot more problematic with the back of the Costco jacket compared to the front. You see here, it kind of looks very similar to the Lululemon trade dress protection. So, Scuba Zip, seems like this is Costco brand. We're not going to go through that, and we're not going to go through the pants. Let's go to the first cause of action, and then we're going to get you guys up out of here. So this one really is a more of a trade dress infringement than a trademark infringement. Obviously, the names are different. The logos are different. However, the trade dress, the non-functional aspects of the jacket, of the pants are very similar from what we have seen, at least in my opinion. But let me know what you guys think in the comment section. Lululemon is the exclusive owner of the trade dress protection. The registered defined trade dress has acquired distinctiveness and serves as a source identifier. That's the whole part of trademarks trade dress. Costco knew or had reasons to know the registered trade dress marks by Lululemon. Nevertheless, subsequent to Lululemon use and adoption of the trade dress marks, the development of secondary meaning in that trade dress, Costco has sold, offered to sell, marketed, distributed, and is still selling, offering to sell, marketing, distributing, and advertising the similar items. Essentially, that's what they're saying. Upon information of belief, Costco conduct is willful, deliberate, intentional, and in bad faith, and is going to infringe the consumer. Confuse the consumers. So they are asking not only for, looks like money, they also want an injunction for them to stop doing so. So again, what do you guys think? I actually think they do have a cause of action. Let me know if you are a Lululemon fanatic. I see a ton of people wearing Lululemon, not just the clothing, but shoes as well as others. And that's women, men, and kids. So kind of let me know what you guys think in the comment section. Hopefully you guys enjoyed this one, man. We went through a lot of information. Again, I apologize for not being able to do this one live. I thought it would have been a lot of good banter going back and forth between the chat. But again, still, nonetheless, let me know what you guys think in the comment section. Like I've said before, please hit that like button for the YouTube algorithm. Please hit that subscribe button to be a part of the IP community. Last but not least, go check out Peace, Love, Intellectual Property, the shirts in the description in the links in the description below. And next week, I'm looking to do this one live, and I can't wait to get back with you guys. So hopefully you guys enjoyed this one. Until next time,